who is the defendant to the counterclaim is directed to pay the counterclaimant the sum of 500,000 naira only, being damages for committing several fundamental and material breaches of the contract between both parties. B, the claimant defendant to the counterclaimant. The claimant, who is the defendant to the counterclaim, is directed to pay 10% interest per annum on the judgment sum until the whole sum is fully liquidated. There are no others as to cost. Parties are to bear their respective costs, and judgment is entered accordingly. Okay. Very well. Okay. Omeje Esquire, can you hear me? Peter Omeje. Anyway, the judgment has already been entered. Yes. Of course, yes. All right. So
is my name
we'll
not in the
take number
judgment
6.
now?
Since the council is inside the court. So bring up number 6.
Just here now.
Is it 7? 7. I don't like this echoing. Where is it echoing? Can't they do anything about it? Please. Okay. Appearances.
So I don't know if we're taking appearances for the judgment my lord just read.
Okay.
The judgment my lord just read.
Yes, somebody's. Yes, I can hear you.
Oh, okay. So for the judgment my lord just read, my name is Peter Omeje.
Okay.
For the judgment my lord just read, yes. Yes, as a court
Okay,
please,
the judgment that has just been read. You are for the claimant.
Yes, as a court please. As a court please.
Okay. The judgment has been concluded. But you get a copy.
Yes, my lord, I was
come here.
My lord, I listened to the judgment.
Okay. So I have to add your name because you have appeared online. Yes.
As a court please. Okay. My name is already on the comment section, sir.
Come again.
My name is already on the chat section. But
I didn't get you.
For the sake of clarity. Okay, I said I'd already typed my name on the comment section on the chat section.
Okay.
But for clarity,
no, I want it to be on record, just in case.
As the court.
In case this case file goes upstairs.
As the court please.
Okay. Esquire.
Yes, for the
for the
claimant,
claimant.
sir. Most grateful.
Defendant today. Mr. Major, how is our Mr. Douglas?
Douglas is better now, sir. Douglas is very better now.
We thank God. Okay. Okay, Mr. Emil Kuma Esquire for the defendants. Is there anybody online for the claimant?
No, my lord. No parties absent. This is for me.
Okay. And this is a ruling. Yes, I know.
You're not.
No, Mr. Major, your case is already over.
It's over.
Yes, my lord. I'm on my way out. Most grateful. I'm on my way out.
Okay. I see.
Your Lordship,
So for this ruling, is anybody here for the ruling?
very well, Your Lordship.
Who?
Olushola Ajao.
Okay. Olushola Ajao. Esquire.
With Adedolapo Akao.
With Ade
Dolapo
Esquire.
Akao.
Yes.
Esquire. And Emmanuel Ubi.
You can prepare though. Esquire.
Very well.
With Emmanuel who?
Ubit. UBIT, Your Lordship.
Okay.
For the applicant, Your Lordship, first defendant applicant.
For the
first defendant / applicant.
What is this one?
Mr. Emiokuma. Somebody is appearing for the defendant.
Your Lordship.
Yes.
Your Lordship.
Yes.
I'm sorry, there was a mix-up. I didn't even know it was because I saw the counsel for the first defendant now that alerted me. Your Lordship, my name is Abiodun Shonaike.
Okay.
And my appearance is for the...
For which case? For which case?
That is
196.
196, Your Lordship.
No, it's not this one.
Okay.
You know, we have five judgments and 3 rulings.
Okay.
But some lawyers are here inside the court. So I quickly took their matters so that we can now...
Okay.
I didn't know you were already online. So the one I'm going to read now is LF 471/2021. That is Mr. Tajuddin Balogun and Echo Bank.
May please, my lord.
Okay.
Yeah, sorry, my lord, sir. May please, my lord. Sorry, I am in this case, my lord.
Who?
Andrew Giribo Esquire, my lord, for first defendant.
No, they are not here. They are not here. So apart from the one I'm seeing now, I don't think the other ones are in this case.
My lord.
Hello, sir. Please kindly listen.
My
Let
lord,
the registrar call the case again so that we know whether it is your matter or not. Please call the case.
471/2021 between Mr. Tajuddin Balogun and Echo Bank Nigeria Limited.
Appearances then.
Please, Your Lordship. Allah Eternal. I appear for the claimant, sir.
Mate? Okay.
Allah Eternal, sir. Allah Eternal.
Allah Eternal. No,
Yes, my lord.
Esquire for the claimant.
Yes, my lord.
May it
So,
please, my
Miss-
lord.
Yes.
I am Andrew Ogiribo. Andrew Ogiribo is spelled Ogiribo. I am for the first defendant applicant.
In which case?
In Mr. Tajuddin Temitope Balogun and
Okay.
OAU and Ekuba, yes, sir, for first defendant applicant.
Okay, but there's only one defendant in that case.
As a court, please, sir.
Your Lordship, I believe that there's been a mix-up somewhere. We represent the defendant applicant, EcoBank Nigeria Limited.
Okay.
Yes, sir.
Who do you represent?
Sir, I represent OAU in that matter, sir. OAU, sir, the first defendant applicant. So I think it's the cost list. There's a mistake on the cost list, sir.
So the ruling is just between Tajuddin Temitope Balogun and EcoBank Nigeria Limited. That is a ruling. It's a ruling. It's not a judgment. It's a ruling.
As a court, please.
As the court pleases. My lord, with the kindness of the court, can I proceed to announce my appearance?
For
EcoBank Nigeria Limited, the defendant applicant.
Are you in the same chambers with Mr. Emiokumo Esquire?
No,
Okay.
I'm in the same chambers with Mr. Abubakar Gianofi.
What of Mr. Emiokumo?
No.
My most noble lord.
Yes.
Yes, I'm from the chambers of Kola Awode, and we filed the preliminary objection, my lord. So we believe this ruling is for the preliminary objection filed.
This one.
Yes, my lord. Yes.
What of Olaiton?
I'm for the claimant, sir.
He's in his chambers. Olaiton. Who?
My lord, if the court may allow me offer a bit of clarity, I think we may have we may align on our understanding. My lord, the first defendant in the case of Obafemi Awolowo University on January 24, 2023 filed a notice of preliminary objection, and my noble lord heard the preliminary objection and ruled on it, and the ruling was dated November 20, 2023, in which the Honorable Court struck out Obafemi Awolowo University from the suit.
Okay.
I'm very surprised they still have an appearance, because operatively they are no longer part of this suit.
Yes, because there's only one defendant in this.
There's
ruling.
only one defendant. There's
only one defendant.
Hence my surprise seeing them being represented in this case.
The person who announced his name is in the same chambers with you.
No, he's not in the same
chambers.
No,
sir. I'm from Kola Awode and Co. So, my lord, we'll take the ruling and then I'll revert back to my chambers.
Okay, the court will read out the ruling. When you come to take a copy of your ruling, we sort out the person we should give the copy to.
As court pleases.
As the court pleases.
Yes. So, because we have 5 judgments and 3 rulings, the court is not going to take the whole hog of the judgments and rulings. The court will either take the beginning and the end, or the end only. So in this particular case, this is the ruling of the court on an application brought by way of motion on notice dated the 13th day of March 2024 and filed on the 15th day of March 2024, pursuant to the relevant laws, rules of court, and under the inherent jurisdiction of this honorable court by the defendant applicants seeking the following. A, an order striking out this suit for failure of the statement of facts to disclose a reasonable course of action against the applicant, and B, for such further orders or other orders this honorable court may deem fit to make in the circumstances of this suit. The grounds upon which the application is brought are as contained in the motion paper. I'm not going into that, but suffice it to say that in his written address, the defendant applicant raised a sole issue for determination, and that is to say, whether the applicant has made out a case entitling it to the grant of the prayer sought in this application. The counsel for the applicant, the counsel made some submissions, which is quite lengthy, which the court is not going to take now. And then at the end of it, he concluded by stating that the honorable court, having struck out the name of the struck out defendant from the suit for want of jurisdiction, should also strike out the suit. The opposition to the defendant applicant's motion on notice, that is the claimant's respondent, filed a counter affidavit deposed to by one Olaiton Lua, a counsel in the claimant respondent's law firm, and a written address wherein the claimant respondent raised a sole issue for determination, and that is to say, whether this suit disclosed a course of action for adjudication against the defendant applicant in this suit. Learned counsel also made copious submissions on this issue. He cited cases and statutes to buttress his points. And at the end, he urged the court to resolve the issue in favor of the claimant respondents and dismiss or strike out the motion on notice with substantial cost. Now, the court will run through the resolution. Having regard to the facts and circumstances of this suit, the pleadings before the court, and the process is filed in support and in opposition to the grant of the instant application, the court distills the issue below for determination, and that is, given the circumstances of this case, is the instant application meritorious and such that ought to be granted? I begin with the issue raised by claimant respondent counsel that paragraphs 3.4 to 3.7 of the defendant applicant's affidavit in support of the motion on notice should be expunged, as some contain extraneous matters by virtue of the provision of Section 87 of the Evidence Act, which provides that an affidavit shall not contain any extraneous matter by way of objection, prayer, legal argument, or conclusion. In the case of Yamo Nigeria Limited and another, the Success Bank, reported in 2017, citation supplied, it was abundantly made clear that, quote, now the position of the law is clear that every affidavit used in the court shall contain only statements of facts and circumstances to which the witness deposes, either of his own personal knowledge or from information which he believes to be true. See Section 115 of the Evidence Act 2011. Whenever a witness deposes to an affidavit and his belief in those affidavits contained therein is derived from any source other than his personal knowledge, he ought to state the facts and the circumstances forming the ground of his belief. In the case of Ajip Nigeria Limited versus Udom Osai and others, reported in 2016, citation supplied, the Court of Appeal held that the test to be adopted in discerning whether an affidavit runs counter to provisions of Section 115 of the Evidence Act 2011, formerly Section 87 of the Evidence Act 2004, can be found in the case of Ishaya Bameye versus the states and others, reported in 2001, citation supplied, where Uwai for JSC put it lucidly that, and I quote him, I think the legal position is clear that in any affidavit used in their court, the law requires, as provided in Section 86 and 87 of the Evidence Act, which has been amended now, that it shall contain only a statement of facts and circumstances derived from the personal knowledge of the deponent or from information which he believes to be true, and shall not contain extraneous matters by way of objections or prayer or legal argument or conclusion. The problem is sometimes how to discern any particular extraneous matter. The test for doing this, in my view, is to examine which of the paragraphs deposed to in the affidavit to ascertain whether it is fit only as a submission which counsel ought to urge upon the court. If it is, then it is likely to be either an objection or legal argument which ought to be pressed in oral argument, or it may be conclusion upon an issue which ought to be left to the discretion of the court, either to make a finding or to reach a decision upon through its process of reasoning. But if it is in the form of evidence, which a witness may be entitled to place before the court, his testimony on oath and is legally receivable to prove or disprove some facts in dispute, then it qualifies as a statement of facts and circumstances which may be deposed in an affidavit. It therefore means that prayers, objections, and legal arguments are matters that may be pressed by counsel in court and are not fit for witnesses, either in oral testimony or affidavit evidence, which, while conclusions should not be drawn by witnesses, but left for the court to reach. Thus, it is settled that where an affidavit indulges in deposing to extraneous matters, legal or speculative conclusions, instead of stating the hard facts, the tendency is such that affidavits or part of its paragraphs may be struck out. I have carefully examined the depositions constituting paragraphs 3.4 to 3.7 of the applicant's supporting affidavit and find them to be of such a nature that counsel ought to urge or impress upon the court through its address, and such that should be left for the court to reach a decision thereon. That is paragraphs 3.4 to 3.7 of the applicant's supporting affidavit contain extraneous matters by way of legal arguments and conclusions, thus offending the provisions of Section 1152 of the Evidence Act as amended. See the cases of APC versus Ifeanyi and others reported in 2023. Citation supplied. Consequently, the said stated paragraphs 3.4 to 3.7 of the defendant's applicant's affidavit in support of the motion on notice are hereby struck out for contravening the provisions of Section 115 sub 2 of the Evidence Act as amended, and as so hold. The crux of the defendant's applicant's application is that the applicant was made a party to this case because of the alleged acts of or omissions of the struck out defendants. That by a ruling dated 30th November 2023, this Honorable Court struck out this suit against the struck out defendants. that the entire case of the claimant respondent hinges on the determination of the issue, whether the struck out defendant had supplied wrong academic information of the claimant respondent to the applicant. That it is the resolution of this issue of supply of wrong information that will enable the Honorable Court to determine the issue of the alleged wrongful dismissal of the claimant's respondent by the applicant. That the Honorable Court cannot determine the issue of the respondent's dismissal from the applicant's employment without considering whether indeed the struck out defendant has supplied wrong academic records of the respondent to the applicant. That the struck out defendant, having been struck out of this suit, there is no reasonable cause of action disclosed against the applicant in the statement of fact upon which the applicant should be asked to defend itself. In law, it is the case of the claimant that gives jurisdiction to the court and not the acts of the parties in the course of litigation. See the case of Amechi versus INEC, reported in 2007. Citation supplied. The Supreme Court, in the case of Oga and others versus Ibe and others, reported in 2019, citation supplied, had this to say on the meaning of a cause of action, and I quote, in tackling whether a cause of action existed for which the suit is initiated in the trial high court would have life, there is a need to go back into the definition of what a cause of action, which has been severally stated in different ways by various courts, to mean a combination of facts and circumstances giving rise to the right to file a claim in court for a remedy. In that is included, among other things which are necessary to give a right of action in every material fact which has to be proved to entitle the plaintiff to succeed. Similarly, in Chevron Nigeria Limited versus Lone Star Drilling Nigeria Limited, reported in 2001, it was held that a reasonable cause of action means either a single or combination of facts averred by a plaintiff in his pleadings, which the law recognizes as giving him right to make claim against the defendant and seeking judicial remedy from the court. See also the case of Thomas versus Olufosoye. It was reported in 1986. Citation supplied. A claimant who feels its rights have been or is being trampled upon has a right to ventilate its grievance before a court of competent jurisdiction. And at that stage, the court is not concerned with whether or not the claimant will succeed in proving his claim. The reasonability of the cause of action is hinged on the chances of the cause of action succeeding and nothing more. The allegations of facts as gleaned from the claimant's statement of facts are that the claimant respondent got dismissed from his temporary job with the defendant applicant based on the information supplied by the struck out defendant regarding the claimant's respondent's final grade from struck out defendant. The fact that the defendant applicant is of the opinion that the claimant's suit has little chance of success or lacks reasonable cause of action in the absence of a particular party does not erode the fact that the claimant has set out its pleadings before the court, a combination of facts relating to a grievance on the alleged violation of his legal rights by the defendant, who he alleges breached his obligation to grant him fair hearing before terminating his employment. This, to my mind, is a reasonable cause of action that the claimant has invited the court to exercise its jurisdiction to not only entertain the cause of action, but enforce the alleged violation of his legal rights. The issue as to whether he has convincing or satisfactory evidence to prove his claims against the defendant on the balance of probabilities is a different ballgame that the court cannot look at or be seen to delve into at this interlocutory stage of the proceedings. This is so as the law frowns on the court looking into and resolving the substance of a case through an interlocutory application, an invitation the defendant applicant seems to be dangling at the court. It is noteworthy that the defendant applicant is not outrightly saying that the nature of the claimant's cause of action is such that the court lacks jurisdiction to entertain. As a look at the claimant's originating process and pleadings reveal that therein has been set out a clause of action bordering on employer-employee relations, which the court, by virtue of Section 254C, sub 1 of the Nigerian 1999 Constitution, as amended, and Section 7 of the National Industrial Court Act, is seized of requisite jurisdiction to entertain. It is in the light of the above that I do not hesitate to find and to hold that the instant application of the defendant applicant lacks merit. His objection is overruled and the application is accordingly struck out. The issue for determination is resolved in the negative in favor of the claimant respondent, and the matter is set down for expeditious trial. I so find and I so hold. There is no other made as to cost. Parties are to bear their respective costs, and ruling is entered accordingly.
We are most grateful, sir, for the well-considered ruling.
Yes, I didn't hear you.
We are most grateful, sir, for the well-considered ruling delivered by your lordship, sir.
Is the engineer in there? Please, let him work on this now. Let him fine-tune everything. I can hardly hear what they're saying. Okay.
We have a date for trial, sir. A date, sir.
Okay. What date? When are we coming again? How do you stand on November the 26th? It's convenient. How about you?
November 26th is convenient.
November 26th.
It's convenient.
Okay. So this matter is now adjourned to the 26th of November 2024 for further hearing. Okay.
My lord, my lord.
Yes.
You said for further hearing, but initially we thought it was for expeditious trial.
What did you say?
You adjourned for further hearing.
Yes.
Or initially said for expeditious trial.
Of course, that further hearing will be done. Okay. How would you have it? You want more than one day? It's going to be expeditiously held.
Yes, I just wanted clarity on what we are adjourning for.
It's for further hearing, which will be done expeditiously.
As the court pleases.
Are you all right? Are you all right?
Yes, yes.
Where is this thing? Oh, it's for trial. Okay. For continuation of trial. For trial. For trial. Okay. So maybe we start from number 1. Okay. Number 1 is Malika. Okay. Okay. Okay, Clement yourself. Okay. Appearances? Okay. Appearances?
May I please the Honorable Court?
Very well.
My name is Moses Olo. I appear for the defendant.
I didn't get your surname, please. Moses O.
Ologu is spelled Ologwu.
Okay.
Ologu.
Spelled as pronounced.
Yes.
Okay.
My Lord.
For the claimant?
Yes, spelled as pronounced.
For who?
My Lord.
With due respect to the Honorable Court,
okay.
O.A. Omotosho for the claimant. O.A. Omotosho for the claimant.
Okay, so Mr. Ologu must be for the defendant.
Yes, the claimant is present.
Okay.
By Zoom.
Very well. Please, I'm glad that we are all together because this is a judgment of 32 pages.
Wow.
Yes, so I think what I'm going to do is to read the introduction and then I read the end of it.
As a copy, please.
Are we all agreed? Are we all on the same page?
Yes, my lord.
Very well. Okay. Now, in this case, the claimant was offered employment by the defendant by the letter of appointment dated the 29th day of December 2014 as a construction superintendent lead in the defendant's operation base / fabrication yard situated at Port Harcourt. The claimant avers that the defendant did not make adequate provisions for his accommodation at Port Harcourt, and that despite the fact that he worked for the defendant from January 2015 till almost the end of March 2015, when he resigned his employment, the defendant only paid him for the month of January 2015. A claim that the defendant vehemently refutes. Consequent upon the above, the claimant, as per his amended statement of facts, claims against the defendant as follows. A. The sum of 1,400,000 naira being outstanding salaries owed by the defendant to the claimant. B. The sum of 3 million naira only as general damages. C. Transfer allowance from Lagos to Port Harcourt being 1,500,000 naira only. and then the cost of this action in the sum of 1 million naira. At the trial, the claimant testified as CW1. He adopted his written depositions as his evidence in chief, and through him, 6 documents were tendered in evidence, admitted and marked as Exhibit C1 to C6, respectively. The CW1 was thereafter cross-examined, and he closed his case. On behalf of the defendant, one Alaba Bello, an admin manager of the defendants, testified as DW1. She adopted her written deposition as evidence in chief. 4 documents were tendered in evidence through her, admitted and marked as Exhibit D1 to D4, respectively. The DW1 was later cross-examined by the defendants, and the defendant closed his case, its defense. The matter was later adjourned to enable parties file and exchange their respective final written addresses to be adopted at the adjourned dates. So it is at this stage that I will go over the defendant. I will jump over the defendant's final written address, which is quite lengthy. He made copious submissions. He referred to authorities to support his submissions. Then at the end of it, he urged the court to dismiss the claimant's claims in its entirety and award substantial costs, while granting an order that the claimant shall pay the defendant 1 month's salary in lieu of it. Then the claimant's final written address is also very lengthy. And the claimant also ended up by urging the court to grant the claims of the claimant as stated in his amended statement of facts. In his in the defendant's reply on points of law, he also made copious submissions. And at the end, he further urged the court to dismiss the suit in its entirety with substantial costs. Then the court started the resolution of the case. The only reason I'm not reading it out is because it is very lengthy, because the court had to examine each and every submission of the learned counsels and stated the legal points on them. So that is where the bulk of the judgment is. So the court is going to overlook that. I will go straight to the end of it. Yes. It is about page 30. Okay, let me go down closer. Okay, let me start from saying that the dates exhibits C5 and D1 was written, that is the 21st day of March 2015. It's a Saturday, when included in the count of the number of days to 27th March 2015. Also including the said 27th March 2015. It is 7 days, which by calendar calculation is a week. But then the CW1's evidence on the day he stopped work is so incoherent or unreliable, and it was controverted under cross-examination, further suggesting that CW1 stopped work before the expiration of his notice. In fact, the claimant had himself in his pleadings and when and written the position stated that the defendant had given a work break due to the forthcoming elections, due to security concerns, a fact the defendant vehemently refuted. And the claimant did nothing to prove the contrary. In law, resignation takes place on the date notice of such resignation was given. In the case of WAEC versus Esowe, reported in 2006, citation supplied, it was held inter alia that a notice of resignation is effective not from the date of the letter or from the date of any purported acceptance, but from the date on which the letter was received by the employer or his agent. Sending a letter of resignation by an employee carries with it the right to leave the service automatically without any benefit, subject to his paying any of his indebtedness to his employer. Similarly, in the case of Adefemi versus Abegunde, reported in 2004, it was held that, and I quote, resignation dates from the date the notice is received. There is absolute power to resign and no discretion to refuse to accept the notice. If resignation will only become effective after acceptance, then payment of salary in lieu of notice of resignation for the stated months will only be effective after the expiration of the months for which the salary in lieu was paid. That cannot be so, etc. unquote. See also Abraham versus Abdallah, quoted in 2019, citation supplied. The court has noted in the instant case that when the days inclusive of the date Exhibit 5 was dated and received is combined, is counted, the length of notice given by the claimant would amount to 7 days. But the evidence before the court points to the fact that CW1 stopped work before the expiration of notice period, meaning in law that he ought to make payment in lieu of notice of such notice. However, when clause 4 of Exhibit C1 is read and interpreted in context, one gets the impression that the payment in lieu contemplated during probation is for a week, unlike the payment of lieu after confirmation, which was categorically stated to be 1 month's notice. The claimant ought to be made to pay the defendant a week's pay in lieu of the notice of his resignation, which he did not wait till his expiration before stopping work for the defendant. I use the word ought because the court appears to be at crossroads in granting such an order, given the long-standing position of the law that the court is not a Father Christmas. It cannot grant what is not sought for by a party in litigation before it. The learned defense counsel making such a prayer in his final address beats the imagination because he ought to know or have known that he could, upon identifying this state of affairs surrounding the claimant's resignation, apply to the court to amend the defendant's pleadings to incorporate a counterclaim, bringing the defendant's pleadings in line with the evidence already before the court. The defense counsel's prayer for order directing the claimant to pay in lieu of notice. As it stands, is not supported by any pleadings, and his address is no substitute for pleadings. See the case of Bature versus Shady and others, reported in 2021. The defendant who alleged that 10,000 naira advanced to the claimant for transport allowance from Lagos to Port Harcourt was refundable could, from the start of his defense, have included a counterclaim while filing his statement of defense or his consequential amended statement of defense. The defendant proceeded at trial to tender in evidence Exhibit D3, a document containing 2 vouchers, one dated the 7th of January 2015 and the other one 10th of January 2015, both of which are copies. The first voucher has the name of the claimant thereon, with particulars described as staff accommodation in the sum of 10,000 naira. The latter of 10th January 2015 has the name of 2 staff. The first being the claimant, with particulars stating, quote, travel expenses, Polycarp Zirafuma's trip to PH from Lagos, unquote, in the sum of 6,000 naira. While it is true that the court has the powers to grant consequential orders upon reaching a finding on a main relief that requires another to give life to it, see the case of Akinsikwe versus Adetoroye, voted in 1999. See also Adamawa State Ministry of Land and Survey versus Alusi, voted in 2021. Citation supplied. I am doubtful that this power extends to granting orders not supported by pleadings or simply arising from counsel's address, which does not constitute pleadings or evidence. In the case of Oyeyemi and others versus Oweye and another, reported in 2017, citation supplied. The Supreme Court per Echo JSC held inter alia that, I quote, reliefs are not sought in the counsel's address or submission. They must be pleaded and served for the defense to respond to it. An address, of course, is not and cannot be substituted for pleading. See Ayanwole versus Odusami, voted in 2011, and also GMB versus Dosumu, reported in 2010. Citations are supplied, unquote. On this note, the said prayer is refused, and I so hold. In conclusion, the court resolves the issue of determination partly in the affirmative in favor of the claimant, such that, save for the orders outlined below or other claims, the claimant fails and accordingly dismissed. The claimant's claims fail and are accordingly dismissed. For clarity, the orders of the court are as follows. A, that the defendant is directed to pay the claimant the sum of 1,400,000 naira, being outstanding salaries owed by the defendant to the claimant. B, the cost of action in the sum of 400,000 naira only, which is awarded in favor of the claimant and is to be paid by the defendant. And that is the judgment of the court, and same is entered accordingly.
We are very grateful for the considered ruling.
Well, you have to read. You have to read it. It's very bulky. Thank you anyway. Okay.
We thank the court for the judgment.
Is that?
We thank the court for the judgment.
Okay, thank you. Okay. Okay. Appearances. Appearances. Online.
My Lord,
Appearances.
my
Yes.
Lord, which matter are we now, my Lord? I didn't hear the name of the case.
Number 3. We are going serially now. You know, when I took up number 7, I didn't know council were online already. But now that I know that almost everybody is online, we are taking it serially. So we are on number 3 now. That is LA 129 2021. Elijah Ejeliku and Swift Networks Limited. Appearances. Online. Okay.
Respect to my Lord. Am I being heard?
Yes.
Yes.
I'm hearing you.
Ada.
Eh?
AF Ada.
Okay. Yes.
Yes. Appear with my learned friend. WF Akasa.
Yes.
Esquire.
Yes.
Akasa is spelled AKAA.
Okay.
SAR.
I see. And you are for the. You are appearing for.
We are appearing for the claimant.
Okay.
Let's call please.
Yes. Yes.
Appearances.
My Lord.
Yes, my Lord. My name is Ikechukwu Nnemeka.
Okay.
My appearance is for the defendant.
Okay. Very well. This I want us to consider my reading the first and last bit of the judgment. Are we all in agreement?
Yes.
Yes, my Lord.
Yes. Very well. So the defendants offered the claimant employment as a rigger in its engineering department sometime on the 27th day of February 2007 through a letter of offer of employment dated 27th day of February 2007. In the course of his employment, there were several reviews by the defendants of the claimant's salary. Also, the claimant rose through the ranks and files to become a technician. On the 19th day of September 2016, while at work, the claimant alleged he was arrested by policemen at the behest of the defendant, only to later discover the accusation leveled against him by personnel of the defendant was stealing of a router. The claimant was eventually charged to court to face a criminal charge, which was subsequently struck out. The claimant alleges that in the course of his employment with the defendant, though the latter deducted from his emoluments monthly for his pension fund contribution, the defendant neglected and or failed to remit the deducted sums to the claimant's pension fund administrator, a claim that the defendant refutes. It is also the claimant's case that following his arrest, his attempts at resuming work with the defendant was prevented by security men on the instruction of the head of human resources of the defendant, who purportedly informed the claimant that he was on indefinite suspension without pay, contrary to the employee handbook. The defendant, on its part, refused this claim, alleging that the claimant abandoned his duties after his arrest. Where of the claimant seeks against the defendant the following: A declaration that the willful refusal by the defendant to honor the provisions of his company handbook, that is terms and conditions of employment, as it relates to its discipline of erring staff, renders all action taken against the claimant null and void and of no effect, and therefore amount to unfair labor practice. B, a declaration that failure to pay the claimant any money while on suspension from work amounts to breach of contract of employment and therefore wrongful, unlawful, and null and void. C, an order compelling the defendant to pay the claimant the sum of 1,936,511 naira 38 kobo, being his outstanding unremitted contributory pension fund, unlawfully withheld by the defendant without justification. D, an order directing and compelling the defendant to pay the claimant the sum of 135,000 naira, being his monthly salaries, from 30th September 2016, when he was placed on suspension without pay until judgment is given in this suit. E, an order compelling the defendant to pay to the claimant 2 million naira as aggravated damages and for maintaining this suit. F, 25% interest on each of the monies claimed herein until judgment sum is completely liquidated. I'm going to jump over the trial where the parties brought people who testified for them, and where exhibits were sorry, I'm coming. Yes, during the trial, the CWO testified, and through him, 11 exhibits were accepted and marked as exhibit C1 to exhibit C11. Then, after that, the defendant also testified and tendered 2 exhibits. Then the court is going to go over the defendant's final written address, where he submitted so many authorities to support his claims. Then the claimant's final written address, he also went to town on his submissions, and he quoted so many cases and laws. And then the defendant's reply address. at the end of it, the court started considering the resolution of this case by considering the circumstances of the instant suit as reflected on the various pleadings, the evidence adduced, and the submissions of counsel. And the court also distilled one issue for determination, and that is, has the claimant made out a case supported by convincing evidence against the defendant to entitle him to the relief sought herein? The court started evidence in line with the principles of law. That is what made it very, very long. And that is why I'm going to leave that one. The court was considering each claims and making its findings on them. And I cannot take all of them because it is quite lengthy. Since we have already agreed that I will do the first and the last, the court will just go to the end where it said that the defendant elected to sideline some procedures which the court has mentioned above, opting for emotional blackmail, show of force as a way to send a clear signal to other employees of their fate should they be accused of stealing the company's properties. It is this lack of discretion that birthed its high-handedness, where it failed to pay the claimant his emoluments because he was accused of stealing. The defendant's remittance of the claimant's contributory pension also stopped in August 2016. The defendant summarily dismissed the claimant without notice, making the claimant anxious and uncertain about the fate and employment status. Rather than admit that bit, he decided to play the ostrich with his head buried in the sand, alleging that the claimant terminated his employment following his long abstinence from work. Cause follows event, and its award is at the discretion of the court, which discretion should be exercised judicially and judiciously. The award, of course, is meant to have some cushioning or palliative effects on the financial burdens of the party in victory. See the case of Anazodo versus Pazmet, Intertrade Nigeria Limited and another, reported in 2023. Citation supplied. For the reasons above stated and given the reprehensibility of the defendant's conduct in the way and manner it orchestrated the arrest of CW1, the court is inclined to award damages and costs in favor of the claimant, which is assessed at the sum of 2 million naira. The claimant's relief 5 succeeds and is granted as prayed. I so find and I so hold. Relief number 6 is for interest on the judgment sum till it is completely liquidated. Order 47 Rule 7 of the National Industrial Court of Nigeria Civil Procedure Rules 2017 empowers the court to award post-judgment interest of not less than 10% per annum upon any judgment. Consequent upon this court awards interest in favor of the claimant on the judgment sum herein at the rate of 15% per annum until the judgment sum is or debt is fully and finally liquidated. On the whole, the issue for determination is resolved in part in favor of the claimant, such that except for the others outlined below, all other claims of the claimant fail, that hereby dismissed. And for the purpose of clarity, the orders of the court in this case are: A, it is declared that the willful refusal by the defendant to honor the provisions of his company handbook, that is the terms and conditions of employment, as it relates to the discipline of erring staff, amounts to unfair labor practice. B, the defendant is compelled to pay to the claimant the sum of 2 million naira as aggravated damages and costs for maintaining this suit. And that is all. And the judgment is entered accordingly.
Right. My Lord, we are very grateful for this well-considered judgment.
Well, okay.
We wish the court more grace, and also wish the court for coming out of this vacation to deliver this lucid judgment.
The court applied for and was given a fiat to do so. Yes, because there are so many judgments, so the court had to apply for fiat and was granted to come and read out some of them.
We are grateful to the court. 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 Yes.
Okay, number what? Number 4 now.
We have to go. They have paid, that means it got we have to go. Let's do
Appearances.
May it please?
Appearances.
May it be?
Yes, of case number LA 213. Amahian Idoni George and Technoglass. Okay. Yes. Appearances.
May it please your noble Lord?
Yes.
I am Abiodun Fadipo. My humble appearance for the claimant.
Okay, Abiodun
Fadipo.
Fadipo. Esquire. For.
Esquire.
For the claimant.
For the claimant, my lord.
Yes. Who's on the other side?
May it please, my lord.
Yes.
May it please, my lord.
Yes.
My name is Otobon Umo.
Come again.
Otobon is spelled O-T-O-B-O-N-G.
Otobon Umo.
Yes, my lord.
Yes.
My lord, I appear with Olawale Isaac Esquire.
Olawale.
For the defendant.
Olawale who?
Isaac Esquire.
Isaac. Okay.
Yes, my lord. For the defendant.
Oh. It's come again. The reason why most of these judgments were not read is because they were quite lengthy. The counsel in these matters, in their addresses, really went to town on all the issues that were canvassed, and the court had to follow them and that made the judgment to be very voluminous also. So I don't know if we can go by the way we've done in others. I take the beginning and the end.
Yes, my lord.
Very well, my lord.
Okay.
Yes, my lord.
Very well. So the claimant was employed as the head of human resources of the defendant on the second day of December 2023. And sequel to his performance, his employment was confirmed on the 5th day of May 2014. I want to believe this is 2013, not 2023. The claimant alleges that he had a cordial relationship with his colleagues and managing director until May 2016, when the manager started becoming abusive towards him. That this inhuman and degrading treatment continued and culminated into wrongful withholding of his salaries over flimsy excuses. That on the 25th day of August 2016, he was invited alongside other staff and were handed over to the police officers from the State Criminal Investigations Department, Panti, Yaba, Lagos State, who handcuffed him and took them away in unmarked cars to the police station, where they were detained for 7 days and were accused of defrauding the defendant of the sum of 200 million naira. And the claimant was further accused of using part of the proceeds to buy a car for his wife. Upon the claimant's release on bail, he was directed to never return to the office premises until further notice. It is also the averment of the claimant that when he was eventually paid his withheld salaries when he was eventually paid his withheld salaries on the 26th day of October 2016, he was paid the sum of 652,220 naira, as opposed to the sum of 1,336,488 naira. The defendant maintained that the deductions from the claimant's salaries was to cover for a project and a laptop, which were hitherto in the claimant's custody. For the claimant, the deductions were done without his consent and were unjustified. The claimant received 2 letters of dismissal from the defendant with the different dates for the year. For these reasons, the claimant had approached this court seeking the following reliefs. We have to be very, very patient here because there are 20 reliefs. The first one is a declaration that the claimant dismissed from the service of the defendant is wrongful. Secondly, a declaration that the employee reference forms dated 7th April 2021 and issued by the defendant is false, mischievous, injurious to the claimant, and also amounts to unfair labor practice. 3, a declaration that the continuous detention of the claimant's salaries and arrears by the defendant is malicious, wrongful, and amounts to an unfair labor practice. 4, a declaration that the arrest and detention of the claimant by the police at the instance of the defendant is wrongful and a breach of the claimant's fundamental human rights to liberty and dignity of human person. 5, a declaration that the seizure and detention of the claimant's Honda CRV with registration number AGL 430DP by the police at the instance of the defendant is wrongful. 6, a declaration that the unilateral pay cut of the claimant's salaries by the defendant is wrongful and an unfair labor practice. 7, a declaration that the failure of the defendant to remit the claimant's pensions for the month of August 2016 to his RSA account as at when due is unlawful and unlawful labor practice. 8, damages against the defendant in the sum of 13,500,000 naira, representing the claimant's 3 years gross salaries for wrongful dismissal. 9, another of this honorable court compelling the defendant to immediately pay the claimant the sum of 2,625,000 naira, be the claimant's outstanding salaries for the months of September 2016 to March 2017. 10, 22,500,000 naira against the defendant, representing the claimant's 5 years gross salary, being damages for false and injurious references issued by the defendant against the claimant and the attendant loss of employment opportunities suffered by the claimant. 11, an order of this honorable court compelling the defendant to immediately pay the claimant the sum of 684,268 naira only, being the remainder of his unpaid salaries from May to August 2016. 12, 9 million naira damages against the defendant, representing the claimant's 2 years gross salaries, being damages for wrongful arrest and the detention of the claimant at the instance of the defendant. 13, 109,519 naira only, representing the claimant's unpaid 2016 leave allowance. 14, 1 million naira damages against the defendant for wrongful seizure and detention of his Honda CRV with registration number AGL 430DP at the instance of the defendant. 15, an order of this court compelling the defendant to immediately remit the outstanding pension sum of 40,439 naira to the claimant's RSA account, pen 100-366-283-122. Amahian Idoni George, maintained with Stanbic IBTC pension managers. 16, 10 million naira only damages against the defendant for brazen acts of unfair labor practice meted to the claimant. 17, 2 million naira damages against the defendant for the malicious and wrongful detention of the claimant's salaries, including the wrongful pay cut by the defendant. 18, an order of perpetual injunction restraining the defendant either through itself, previous, assigns, agents, or any person acting through it from issuing any further false and injurious reference against the claimant. 19, interest of 21% per annum on the sum stated in paragraphs 8 to 12 sorry, 8 to 17 above until the judgment sum is paid. And lastly, 20, 2 million naira only being the cost of this suit. Upon the commencement of trial, the claimant testified everyone and adopted his as his evidence. Through him, documents were tendered and admitted and marked as C1 to C18, respectively. CW1 was cross-examined. Godwin Ehie Nobele testified as CW2. He adopted his written deposition as his evidence and was cross-examined, after which the claimant closed his case. John Alubu, MD, and Chief Executive Officer of the defendant, testified as DW1. He adopted his written depositions, and through him, documents were tendered and admitted and marked exhibits D1 to D6, respectively. DW1 was duly cross-examined, and the defendant closed his defense, and the matter was adjourned to enable the parties file and exchange their respective final addresses to be adopted on the adjourned dates. So, the defendant submitted his final written address, wherein the counsel had made copious submissions, and at the end concluded by stating that the damages for injury to reputation arising from wrongful dismissal are irrecoverable unless the injury results in pecuniary loss, and referred the court to the case of Omuneme versus ACBPLs. Citation supplied. The learned counsel for the claimant submitted his own final written address, wherein he cited many authorities and laws, and at the end of it, urged the court to find for the claimant. So the court itself started the resolution of the matter by examining what was before it. The court distilled one issue below for determination, which is, has the burden of proof been discharged by the claimant to entitle him to the reliefs sought in this suit? So the court went on to take cursory looks at all the exhibits and the positions in law of the submissions of both learned counsel. This went on and on and on. The only little problem we have is that as the court was going on, it would take one of the reliefs and examine it. To take relief number 1 and examine it and give his finding on it. That is what made it so long, because there are 20 reliefs, which the court cannot now read out. So, I will go straight to the end. Relief 19 is for interest on the judgment sum at the rate of 21% per annum, while relief 20 is for cost of action at the sum of 2 million naira. Relief 19 is for post-judgment interest, which is the interest courts are statutorily empowered to award and not usually contemplated by parties in advance. It is unlike pre-judgment interests, which must be specifically pleaded and proved. See the cases of Rematon Service Limited versus NEM Insurance PLC, reported in 2020. See also Sky Mix Motors Limited versus UBA PLC, reported in 2021, and GTB PLC versus Obosi MFB Limited, Supra. Citations fully supplied. Order 47 Rule 7 of the National Industrial Court Civil Procedure Rules, that is the instant rules of this court, empowers the court to award post-judgment interest of not less than 10% per annum upon any judgment. In the light of the above, the court awards interest at the rate of 15% per annum on all the judgment sums in this suit until same is fully liquidated. On the issue of cost of action, the purpose of award of cost is supposed to be compensatory to a successful party without being punitive to an unsuccessful party. See the case of Olusayan versus Oshinleye, reported in 2013. When a suit is partially successful or successful, it becomes a matter of discretion by the court whether or not to award costs or what other on costs would be. On this note, the court assesses the cost in the sum of 300,000 naira in favor of the claimant to be paid for by the defendant, and I so hold. In conclusion, the issue for determination is resolved partly in favor of the claimant, such that the orders enumerated below, all other claims of the claimant fail and are hereby dismissed. The order of the court are as follows. A. It is declared that the dismissal of the claimant from the services of the defendants was wrongful. B. It is declared that the employee's reference form dated 7th day of April 2021 and issued by the defendant is false, mischievous, injurious to the claimant, and also amounts to unfair labor practice. C. It is declared that the unilateral pay cut of the claimant's salary by the defendant is wrongful and an unfair labor practice. D. It is declared that the failure of the defendant to remit the claimant's pension for the month of August 2016 to the RSA account as at when due is unlawful and unfair labor practice. E. Is that the defendant is hereby ordered to immediately pay the claimant the sum of 684,268 naira only, being the remainder of his unpaid salaries from May to August 2016. F. The defendant is also ordered to immediately remit the outstanding pension sum of 40,439 naira to the claimant's RSA account with the given number maintained with the Stanbic IBTC pension managers. G. Damages in the sum of 187,500 naira, being 2 weeks' wages or salaries of the claimant for the wrongful dismissal of the claimant. H is the cost in the sum of 300,000 naira, which is awarded in favor of the claimant to be paid by the defendant, and that is the orders of the court, and that is the judgment of the court.
As the court pleases.
Okay, I'm sure when you read it, it will be more meaningful. Yes.
My Lord, we are most grateful for the well-considered judgment.
Thank you.
We appreciate the court for the time and patience reading through the voluminous final submissions of counsel and coming up with judgment today. We really appreciate the effort of the court.
Thank you very much. Thank you very much. The court is delighted to hear that. But it was running late. And you know we are given the time within which to deliver this.
Yes, my lord.
My lord, I can't hear anything from that side, my lord. I'm in case number 5.
That's number 5. Okay, that's the one that you are going to check now. So I've called for appearances.
Okay, my lord.
Yes,
with utmost and honor to this honorable court, I am Abiodun Fadipo. My humble appearance is
yes. 4. Mr. Abiodun.
My lord, yes, my lord.
You are appearing for the
claimant. For the claimant, my lord.
Okay. Yes. It's on the other side.
Respectfully, my lord,
Yes.
My appearance is for the defendant.
Okay, come again, please.
Onopemipo, Onaopemipo.
Yes.
Oguntayo.
Oguntayo.
For the defendant, my lord.
Okay. It's also a judgment. Thank you. Okay. So the court also take the beginning and the end because there are all other rulings to be confirmed. So can you hear me? Counsel?
Yes, my lord, we can hear you.
Okay. So this judgment, just like others, will consist of the beginning and the end for obvious reasons. This is not the last. So please bear with me. I will take the beginning and the end. Then the judgment is ready. When you come, you get the copies of your judgment, and then you can read in details and then make up your mind what you want to do with the judgments. Are we all agreed? Are we on the same page?
Yes, my lord.
Okay.
Very well, my lord.
Okay. Now the claimant was an employee of the defendant, employed as the national lead, in bracket cardiovascular, on the first day of February 2017, with gross salary of 750,000 naira only. The claimant was subsequently appointed the regional sales manager, Southwest, on the 10th day of February 2020. The claimant alleges that the defendant notified him of a purported redundancy exercise, which eventually led to his termination, the termination of his employment, contrary to the relevant statutory provisions and international best practices. He further alleges that despite drawing the attention of the defendant to the irregularities through his solicitors, requesting for a meeting to negotiate his redundancy pay, the defendant ignored the request to negotiate any redundancy pay with him, let alone pay him any redundancy fee. It is for this reason that the claimant claims the following from the defendant. A declaration that the termination of a declaration that the termination by redundancy of the claimant's contract of employment by the defendant is wrongful. B, 27 million naira only, representing the claimant's 3 years gross salary, being damages against the defendant for wrongful termination of employment. And C, 1 million naira only, being the cost of this suit. Upon commencement of hearing, Paul Eribo, the claimant, testified as CW1. He adopted his witness statement on oath as his evidence before the court and tendered 9 documents in evidence, which were admitted and marked as Exhibit C1 to C9 respectively. CW1 was then cross-examined. Thereafter, the claimant closed his case. Then Mr. Adetunji Ali, the finance manager of the defendant, testified as DW1. He adopted his written deposition on oath as evidence. Through him, 2 documents were tendered in evidence, admitted and marked as exhibits D1 and D2. DW1 was duly cross-examined and the defendant also closed his defense. And the matter was adjourned to enable parties file and exchange their respective final addresses to be adopted on the adjourned dates. So the defendant in his written address raised the following issues for determination, and these are: A, whether or not the defendant can declare the role of the claimant as redundant, and whether ample notice was given to the claimant. B, whether the defendant commenced redundancy pay negotiations with the claimant. C, whether the defendant can be held liable for wrongful termination of employment. So on this, the Learned Defense Counsel submitted at length, and as usual, we cited so many cases to buttress his point. And at the end, he urged the court to hold that the claimant has not proven that his employment was wrongfully terminated, and the court is duty bound to have recourse to the contract of employment to ascertain whether any term was breached. Following this, the claimant's counsel also submitted his final written address, and in his final written address, he distilled the following issues for determination, and these are: A, whether the termination of the claimant's employment on the ground of redundancy, but without prior negotiation of redundancy pay with the claimant is wrongful. B, whether the termination of the claimant's employment on the ground of redundancy, but without redundancy pay is wrongful. And C, whether the claimant has proved his case to be entitled to the relief sought. Counsel also went to town in his submissions on these points, on these issues that he distilled. And at the end, he maintained that the defendant's argument that it inadvertently used the word severance pay when it meant redundancy pay is an afterthought, and that it is untrue that Exhibit C3 activated a negotiation of redundancy pay. Then, following this, the defendant's counsel made his reply on point of law. He submitted copiously on this and cited more cases. And that was the end of the final written addresses. The court started its resolution by looking at the facts and circumstances of the suit, and the process is filed by the parties hearing the evidence adduced and the submissions of learned counsel in the final written addresses. The court distilled a sole issue for determination, which is whether the claimant has proved his case to be entitled to the relief sought. As usual, the court looked at all the submissions in line with legal principles, and together, in fact, it will be seen that they were weighed to know which one was acceptable and which one was not acceptable. And at the end, the court said, in a claim for wrongful dismissal from employment, the measure of damages is prima facie the amount that the claimant would have earned had employment continued according to the contract. Where the claimant was, by terms of the contract, entitled to be given 1 month notice before the termination of his appointment by the employer, the claimant is only entitled to be paid the amount he would have earned or entitled to be paid within the period of 4 months and no more. See Nigeria Produce Marketing Board versus A.I. Adewumi, reported in 1972. And also see Western Nigeria Development Corporation versus Abimbola, reported in 1966. And also Kato versus CBN, reported in 1999. Citations fully supplied. Okay. See also Banye versus UBN PLC, reported in 2018, with the citation fully supplied. Parties are bound by the terms of their contracts. Therefore, if the conditions for the formation of a contract are fulfilled by the parties thereto, they will be bound. Unless it is established in evidence that a party was fraudulently led into an agreement, parties are bound by the written and express terms of their contracts. In other words, in the absence of fraud, duress and undue influence or misrepresentation, Parties are bound by their contracts. See the cases of Chidoka versus First Finance Company Limited, voted in 2013. See Makwe versus Woko, voted in 2001. See Alade versus Alik Nigeria Limited, reported in 2010. All citations all fully supplied. It is not the function of a court to make a contract for the parties or to rewrite the one which they have made. CUBN versus Osigi, voted in 1994. Citation supplied. From Manager 1 of Exhibit C1, the claimant is entitled to 1 month's notice period since his employment had continued for 1 year, in this case from 2017 to 2021. Although the claimant was given a month's notice and salary in lieu of notice as per redundancy, because it was perfunctory, and the court must recognize the defendant's intention to let go of the claimant, the court is inclined to award the sum of 715,000 naira only, being the sum the claimant would have been entitled to be paid during the 1 month notice period, in line with the terms and conditions of his employment in the interest of justice. Accordingly, the claimant's relief number 2 succeeds, and I so hold. The claimant for his relief number 3 is seeking 1 million naira as cost of the suit. The award of costs is at the discretion of the court, which must be exercised judicially and judiciously. In the case of Yakubu versus Ministry of Housing and Environment, Bauchi State, reported in 2021, it was held that the general rule is that costs follow events, and the successful party is entitled to costs, and the award or refusal of costs is at the discretion of the court, provided it is exercised judicially and judiciously. See also Order 55, Rule 4 and 5 of the National Industrial Court of Nigeria Civil Procedure Rules 2017. The court hereby awards the cost of 200,000 naira in favor of the claimant and against the defendant. On the whole, the issue for determination is resolved partly in the affirmative in favor of the claimant. And for clarity, the orders of the court in this case are: 1, it is hereby declared that determination of by redundancy of the claimant's contract of employment by the defendant in breach of the provisions of Section 21C of Labor Act is wrongful, and the defendant is hereby ordered to pay to the claimant the sum of 750,000 naira only, being the sum the claimant would have been entitled to be paid during the 1 month notice period, in line with the terms and conditions of his employment, and also the sum of 200,000 naira being cost of this suit. And this is the judgment of the court, and it is entered accordingly. Okay.
As the court pleases, we are most grateful, my lord, for the well-considered
Thank
judgment.
you very much. Okay.
We are most grateful for the well-considered judgments.
Thank you very much. Okay. Register. The next one. The next one is we've done 6. We've taken 6. Okay. Okay, we took 7.
And 1, mobile producing Nigerian on import. So, is there no because?
Okay. Appearances.
Medical Okay.
Yes.
Abiodun Shonaike.
Okay.
With me is Oluwaferanmi Alatise.
Sorry, with you is Oluwa did what? Feranmi
Alatise. Our humble appearance for the claimant's respondent.
Okay. Yes.
With profound respect to the court.
Yes.
Olushola Ajao. Olushola Ajao.
Okay.
My learned friends, Adedolapo Akao. And Emmanuel Ubit.
Emmanuel
Ubit, U-B-I-T, Your Lordship.
Okay, okay.
I'm grateful.
Yes. Yes.
For the first defendant applicant.
Yes.
We are grateful, Your Lord.
Okay.
May it please the Honorable Court.
Yes.
I'm John Chriso Eze.
John
Chriso. John Chriso is spelled Johnchryso. Surname Eze.
Oh, please, you come again with your name. John Briscoe.
John Chriso, Johnchryso. Eze.
Okay.
Appearing with me is Oluwapelumi Okujenyo. And Naomi Jones Biere.
John Biere, is it a compound name?
Yes, my Lord. Jones, Jones hyphen Biere, Bieyere, my Lord.
Okay.
Our appearance is for the second defendant, my Lord.
Very well.
Let us start.
Everybody has a very long name. That's what I've noted. Now, this is the ruling of the court on a notice of preliminary objection dated the 17th day of May 2024, filed on the 20th day of May 2024, brought pursuant to the relevant statutes and rules of court, wherein the first defendant applicant seeks A, an order of this honorable court striking out the claimant's reply dated 17th April 2024, and all accompanying court processes, including the motion on notice dated 17th April 2024. So first defendant applicants further amended statement of defense in its entirety for being incompetent and want of compliance. Hello?
I'm sorry.
My Lord, with respect, this is our ruling. It appears there's a mix-up.
My Lord, there's a mix-up.
This is number 6. Number 7. It should be number 7, Your Lordship.
Okay.
Number 6
number 7 has been taken.
Number 7 has not been taken, Your Lordship.
Your Lordship, number 7 was not taken.
Number 7 is Mr. Tajuddin Temitokwe. Is it?
No, Your Lordship. That's number 6.
My number 6 is Paul Arinze.
Number 7 is
What
my
is
Lord,
your number 7?
Appearing for number 6, and that is Paul Arinze. You are correct, my Lord.
Eh?
My Lord, from the list sent to us,
yes,
the number 7 is Medical and Health Workers Union of Nigeria.
Okay.
From the list sent to us, my Lord.
Okay, but that one is my number 8.
Oh, I think that's
my own number 6 now, number 7 now. Which one are we taking? The one we are taking now is Paul Arinze. Paul Arinze and Mobile Producing Nigeria Unlimited. That's the one I'm taking now.
Oh.
Then number 7 is Tajuddin Temitokpe Balogun and EcoBank. We have taken that one.
Yes,
the last one on my list is Medical and Health Workers Union of Nigeria and Comrade Olatunji Mobolaji Johnson.
Oh, my Lord, that's the one myself and Mr. Ajao is in.
Okay.
And from the list sent to us, it's written is at number 7, Your Lord. That was where the bishop occurred.
Okay. Okay, but Mr. Abiodun Sonaike.
Yes,
which
my
one
Lord.
are you in?
I'm in number 8, the one that my Lord has as number 8, because it was sent as number 7 to us.
Okay.
So myself and Mr. Ajao is in the same matter, number 8. My Lord's number 8. Yes, my Lord.
Number 8. So, Mr. Abiodun, you are for the medical and health workers too?
Yes, my Lord.
Okay. And, okay, in that case, maybe you should just bring the case file. Or you remove this and put this. Bring up the case file. We remove this. So I should now read out number 8.
We are grateful.
Number 8.
Most obliged, my Lord.
We are grateful.
Well, you know what I'm going to do, since all of you are in number 8.
Yes, Lord.
I will now just simply go ahead and read out number 8. Is that all right by you?
Very well.
My Lord, I announced clearance for the second. I'm not in number 8, my Lord. I'm in number 6, my Lord. And that's
please, what's your name?
John Christo is appearing with Oluwapelumi.
Okay. Okay, so Mr. Abiodun Sonaike, you are in number 8. You are in which one?
In number 8, my Lord.
Okay. Then
Olushola Ajao.
Yes. Olushola Ajao. Yes. With Ade Dolakpo account.
And
Emmanuel Lutit.
Yes,
both of you are in number 6.
8, we're in number 8. Yes, sir.
Okay, Mr. Eze, with Oluwapelumi.
Yes, my Lord.
You are the only one in number 6.
No, my Lord. My Lord, we are here. I'm number 6, my Lord.
I'm number 6 too, my Lord.
We are in number 6. We are in number 6, my Lord.
We are number 6. I'm the claimant counsel, my Lord.
The matter wasn't mentioned. That was it.
Let's just continue with the number 6. You can strike it up and write their names again.
Okay. Now, because I said I was going to read all these things serially, because when I jumped onto number 7 on my list, I didn't know that learner council were already online. So I started doing it serially. So now I'm going to read number 6. After that, I read number 8.
As the top
As a copy.
Yes. So number 6 is this Paul Arinze. So the one I'm reading is for Mr. Paul Arinze and Mobile Producing Nigeria Unlimited and Esowe Mobile Corporation.
My lord.
No, I will. So for this particular one, with suit number NICN/LS/288/2019, please, appearances.
Respectfully,
yes.
My name is Esowe Azaino.
Esowe
Azaino, my lord. And
spelled as pronounced.
Yes, my lord. Azaino is spelled A-Z-A-I-N-O. A-Z-A-I-N-O. My lord, appearing with me.
Okay. Yes.
Juliet.
I've got. Okay. You're appearing for
the claimant, my lord.
Claimant. Okay. Yes. Who else? Who
May
is on
place
the
my
other
noble
side?
lord. Yes, my lord.
Yes.
My name is P.E. Ogiego.
E.E.
P.E. Ogiego. Ogiego.
Ogiego
is spelled O-G. Yes, my lord. O-G-I-E-G-O-R. I make a humble appearance for the first defendant applicant.
I don't know. Your voice sounds very far. It's like you're very, very far away. Okay.
Well, my lord, yes, ma'am.
Okay. I've taken the appearance for the first defendant. So who is for the second defendant?
For the second defendant, my lord, John Christo Eze.
Okay.
Appearing with Oluwatobi Okujeyo,
Okay.
Oluwatobi Okujeyo, and Naomi Jones Biere, my lord. Our appearance is for the third defendant, my lord.
Okay. So this is the ruling for that case. Now, this is the ruling of this court on a notice of preliminary objection dated 17th day of May 2024, but filed on the 20th day of May 2024, and brought pursuant to the relevant statutes and rules of court, wherein the first defendant applicant seeks an order of this honorable court, striking out the claimant's reply dated 17th April 2024, and all accompanying court processes, including the motion on notice dated 17th April. To the first defendant's applicant's further amended statement of defense in its entirety for being incompetent and want of compliance with the relevant rules of practice and procedures and extant laws. The second prayer is the omnibus prayer, and the grounds upon which the application is brought are as contained on the face of the motion paper. The application is supported by a 10-paragraph affidavit deposed by one Priscilla Inegbenehi, a legal practitioner working with the law firm representing the first defendant applicant. Attached to the affidavit is an exhibit. In his written address, the first defendant applicant formulated these issues for determination, to which A, whether the claimant's reply filed on the 17th April 2024 is not liable to be struck out, the signature therein having not been linked to any of the 5 listed legal practitioners on the said reply. B, whether the claimant can rely on its written statement on oath in opposition to the first defendant's further amended statement of defense, having raised fresh issues and facts therein, and which the first defendant has no right of response according to the rules of pleadings. Arguing the two issues conjunctively, learned counsel for the first defendant applicant contended that the claimant's reply of 17 April to his further amended statement of defense is liable to be struck out on grounds that the signature on it cannot be linked to any of the 5 legal practitioners listed on the process as claimant's counsel. He referred the court to GTB versus Innocent Nigeria Limited, reported in 2017, 16 Nigeria Weekly Law Report, part 1591, page 181 at 197. Also, that the claimant's reply of 76 paragraphs raised numerous new issues and facts which are not part of the statement of facts. That in law, a claimant is not allowed to introduce new issues in his reply without leave of court. He must not also raise new grounds of claim different from what is contained in his statement of claim. He referred the court to Olabodun versus Lawal, reported in 2008, citation supplied. Counsel submitted that the new issues raised by the claimant's reply were raised without leave of court, and the defendant has no right of response to the new issues. He then urged the court to discountenance the claimant's reply. In opposition to the said application, the claimant filed a 10-paragraph counter affidavit deposed by one Jesu Fumi Adekoya, a legal practitioner in the law firm representing the claimant's respondents. Learned Claimant Respondents Council adopted the issues formulated for determination by the first defendant applicant. Council argued that the bar practicing fee payment receipt of the counsel that signed the claimant's reply filed on the 17th of April was attached to the process, and that the applicant never denied that it was the counsel whose receipt was attached that signed the process. Besides, the non-ticking of the counsel's name at the signature portion of the process is of no consequence, as the name on the MBA seal or receipt indicates the legal practitioner who signed it. He referred the court to the case of Minor versus EFCC, reported in 2020, and also Annie and others versus Efiok and others, reported in 2023, citations fully supplied. Claimant's counsel proceeded to contend further that it is elementary law that a claimant's reply is filed to address new issues or allegations of facts contained in the defendant's statement of defense, which the claimant seeks to challenge, deny, or admit, referring the court to Unical and others versus Efiong and others, reported in 2019, citations supplied. The applicant's supporting affidavit and written address did not point out what new issues were contained in the claimant's reply. The applicant cannot send the court on a fact-finding mission of going through all the pleadings to know what new issues were raised. That the only duty of the court is adjudication, not investigation. He referred the court to the case of Atikpe versus Joe, reported in 1999, and also Akin Tokun versus LPDC, reported in 2014, citation supplied. Went on to say that the onus is on the applicant who alleges new issues were raised to prove the existence of such new issues contained in the claimant's reply. Counsel urged the court to refuse the relief sought by the first defendant's application in its application. The court has carefully considered the facts and circumstances of this suit and examined the pleadings and the processes filed in support and in opposition to the grant of the instant application. and detail this issue for determination, and that is to say, is the instant application meritorious and such that ought to be granted in the interest of justice? Learned First Defendant Applicants Council contends that the claimant's reply filed on the 17th of April alongside the application filed seeking to regularize same are incompetent. To him, the reply is incompetent because the legal practitioner who signed it did not tick his name, and because it raised raised new issues different from what was contained in the claimant's statements of facts without seeking leave of court to do so. On the issue of non-ticking of counsel's name for purpose of identifying which legal practitioner signed the claimant's reply, may I quickly note that the arguments conversed by the applicant's counsel used to be the position of the law, but the law as it is now, stands, is where the identity of the legal practitioner that signed the process can be identified through his MBS seal or bar practicing fee receipt, so long as it is not in doubt that it is a legal practitioner that signed the process is competent. See the case of Annie versus Esowe, reported last year, 2023, at Nigerian Weekly Law Report, part 1087, page 463. It needs to be reiterated that justice cannot and must not be sacrificed on the altar of technicalities. Over-reliance on technicality leads to injustice, and the duty of the court is to dispense justice. The era of dependence on technicalities is long gone and better forgotten. The current trend is for courts of law not only to do justice, but to ensure the doing of substantial justice between the parties. This can only be achieved by, as much as possible, jettisoning technicalities. The law allows room for human error. Reliance on technicalities, which could be due to human error and slip-ups, leads to injustice. Justice can only be done if the substance of the matter, rather than the form, is attended to in the consideration of these matters. Trivial and trifling mistakes or errors are likely to be made by litigants and counsel from time to time, and this should, however, not deprive a party from having his complaint or matter properly ventilated and determined on the merits. See the case of Maitumbi versus Baraya, reported in 2017, and also KSPWB versus Baba, reported in 2018, citations supplied. In the light of this, the issue of non-ticking of the legal practitioner's name who signed the claimant's reply is resolved against the first defendant applicant and the submissions on same discountenance, and I so rule. On the issue raised by the applicant's counsel that the claimant's reply contains new issues by the rules, and by the rules of pleadings, it cannot respond to them. Fidelis Nwadialo, Senior Advocate of Nigeria, in his book, Civil Procedures in Nigeria, second edition, published in 2000, at pages 404 to 405, had this to say on pleadings subsequent to a reply, and I quote him: "It is not often that there is need for a reply, and when one is filed, the pleadings almost invariably close with it. However, other pleadings subsequent to a reply may be filed. Each of these may be filed for the same reason for which a plaintiff may file a reply. First, a defendant may file a further pleadings in order to deal with the new matters that might have been raised by the plaintiff's reply. A defendant's pleadings which he files in answer to a reply is called a rejoinder. In the same way, the plaintiff, a defendant's pleadings which he files in answer to a reply is called a rejoinder. In the same way, the plaintiff may answer a rejoinder by a sole rejoinder, which in turn may still be followed by a rebuttal. Sorry, 1 minute, come. I'm sitting. I'm sorry. A defendant's pleadings which he files in answer to a reply is called a rejoinder. In the same way, the plaintiff may answer the rejoinder by a sole rejoinder, which in turn may be followed by a rebuttal by the defendant, and this is by a sole rebuttal by the plaintiff. In practice, none of these pleadings is filed, and if ever any of them is necessary, it can only be filed with the leave of court. Be that as it may, I have painstakingly gone through the said claimant's reply, as well as the first defendant's further amended statement of defense, and observed that raised in the claimant's reply were expansive response to allegations of fact contained in the first defendant's further amended statement of defense. There were no such issues to my mind that changed the claimant's course of action as contained in his statement of facts, or rather amended statement of facts. Under the rules of pleadings, the elaboration of facts in the claimant's reply without changing his course of action or introducing a new course of action is regarded as new assignments. The first defendant applicant in his further amended statement of defense made allegations of facts as touching the legal issues of second defendant in relation to it, the competence of the claimant in the discharge of his duties, the tendency for insubordination in the claimant's conduct, the spreading of false and malicious information by the claimant, amongst other things. It is all these issues and allegations of facts that the claimant responded to in his reply. It behoved the applicant to have adverted the mind of the court to specific portions of paragraphs of the claimant's reply that constituted new course of action, or that they were inconsistent with the allegations of facts contained in the claimant's amended statement of facts. See section 131 of the Evidence Act as amended. In the case of Abdullahi versus Government of Kano State, reported in 2014, it was held inter alia that, quote, the proper function of a reply is to raise in answer to the defense any matter which must be specifically pleaded, which otherwise might make the defense take the defense by surprise, or which raises issues of fact not arising out of defense. In other words, the plaintiff must not set up in his reply a new course of action which is not raised either on the writ or in the statement of claim, since the plaintiff must not in his reply make any allegation of fact or raise any new ground of claim inconsistent with his statement of claim. Inconsistent with does not mean mutually exclusive, but merely new or different. In other words, the reply must not contradict or depart from the statement of claim, or it will be a ground for an application to strike out the reply in which the defect occurs, unquote. See also Achilihu versus Anyaton, reported in 2013. Citation supplied. So having gone through the claimant's reply, the court is of the considered view that the allegations of facts therein are largely elaborate answers to the first defendant's defense, as contained in his further amended statement of defense. Consequent on this, the issue for determination is resolved in the negative, and the first defendant applicant's objection is overruled and discountenanced. The claimant may proceed with his application of 17th April 2024, and I so hold. There is no others to cost and parties to bear their respective costs, and ruling is entered accordingly.
I'm most grateful, my Lord, for the well-considered ruling.
Thank you.
My Lord, in the light of the circumstance, will be confirming my.
Come again.
My Lord, in the light of the circumstance, we'll be confirming for the trial dates. If it stands, my Lord, we do have the 10th of October, which I am of the knowledge that the court may not sit due to the judges' conference. So I don't know if we can have a further date, because we do have on the 10th and 21st of October. So subject to the Lord, not convenient, if we can have a further date. Since the
let me just quickly say that 10th will not be the 10th is it cannot hold on the 10th. It's not convenient for the court because we are having our new legal year celebration.
Yes,
and
my Lord.
None of our courts will sit from the 7th to the 10th, I think. So that 10th will be when we are coming back. So we have 2 dates for this. The other one is it 21st?
21st, my Lord.
So maybe that one. Do we consider that one?
Yes, my Lord. I was hoping we can get another date to add with that one, since it's coming out for trial.
Okay, to make it 2.
Yes,
okay.
my Lord.
Okay, my registrar. Find another date and add it to the one of 21, the 21st, so that it will still be 2.
We suggest 17th of October, my Lord.
No, we're going through the diaries, our diary, to see what dates.
I think it's not convenient.
How about 20? Okay, what do you say about 22, 21st and 22nd?
Convenient, my Lord.
Very well. Okay.
My Lord, 22nd of October.
Yes.
Yeah, it's convenient.
It's convenient, my Lord.
I see. So this matter is now adjourned to the 21st and 22nd days of October 2024 for continuation of hearing.
As the court pleases, my Lord.
As the court pleases.
As the court pleases.
I'm most grateful, my Lord.
21st and 22nd. Okay, now bring the last one. Okay. Appearances.
Abiodun Shonaike.
Okay.
With me is Olamiya for the claimant.
Okay, you're appearing with who?
Oluwaferanmi Alatise.
Okay, Oluwaferanmi
Alatise.
Alatise, okay. Alatise. Esquire.
Yes, my Lord.
Oluwaferunmi.
Oluwaferunmi. Ferunmi. Oluwa Feranmi, my Lord.
Okay, Ferami.
Feranmi, my Lord.
Okay, Ronmi. Okay. Alatisha. Esquire.
Yes, my Lord.
For who?
For the claimant respondent, my Lord.
Very well. Okay. Who's on the other side?
With profound respect to the court, sir. I'm
Yes.
Olushola Ajao. Olushola Ajao, your Lord.
Yes.
My learned friends, Adedolapo Akao. Adedolapo Akao, your Lord. Adedolapo, as pronounced. Akao, A-K-A-N-O. And Emmanuel Ubi.
Akao.
Akao, A-K-A-N-O.
Esquire. Yes, and Emmanuel.
And Emmanuel Ubit, your Lord. Ubit is spelled U-B-I-T, your Lord.
Okay. Is he a Nigerian?
Your Lordship, our parents.
Okay.
We appear for the first defendant applicant, your Lordship.
Okay.
We are grateful, sir.
Yes. First defendant applicant. Okay. So this is the ruling of this honorable court on the notice of preliminary objection brought by the first defendant applicant seeking the following. An order of this honorable court striking out or dismissing this action against the plaintiffs for want of jurisdiction on the ground that the plaintiff's action is non-compliance with statutory requirements having regard to the provisions of Rule 28, sub 1, 2, 3, 4, 5, and 6 of the Constitution of Medical and Health Workers Union of Nigeria 2021, which provides for resolution of conflict between members or between members and the union. The last prayer is the omnibus prayer. The application is supported by a 7-paragraph affidavit deposed by Comrade Johnson Adeboye Adegoke, the first defendant herein. In his written address, the first defendant applicant raised the following issues for determination, and these are: A, whether the claimants have complied with the have complied with or satisfied the provisions of Rule 28, subs Rule 1, 2, 3, 4, 5, and 6 of the Constitution of the Medical and Health Workers Union of Nigeria to clothe this court with jurisdiction to hear and determine this suit. B, whether the non-compliance with Rule 28, 1, 2, 3, 4, 5, and 6 of the Constitution of Medical and Health Workers Union of Nigeria by the claimants, this court has jurisdiction to hear and determine the suit. Learned counsel to the applicant submitted that it is the law that where a statute provides a process of pre-action remedies for an action before going to court, an aggrieved party must exhaust all the remedies before proceeding to court for redress. He referred the court to the case of Owosheni versus Faloye, reported in 2005, where the Supreme Court held that, I quote, where a statute prescribes a legal line of action for the determination of an issue, be it administrative matter, chieftaincy matter, or a matter of taxation, the aggrieved party must exhaust all the remedies in law before going to court, unquote. Also, in the case of Ogologo and others, Esowe and others, reported in 2005, the Supreme Court also held that, quote, where a law has given exclusive power to a body to decide, the court cannot come in before that body has exercised that power. Courts can come in only when there is exhaustion of all the remedies before that body, and court will then be able to decide whether that power has been exercised lawfully. The Legal Council further submitted that the provisions of section 28, 1, 2, 3, 4, 5, and 6 of the Constitution of the Medical and Health Workers Union of Nigeria is a condition precedent for this dispute resolution. That in the present case, between members of the union, the claimant had not exhausted the above channel of internal settlement of dispute before filing the present suit. Counsel urged the court to dismiss the suit with substantial cost. In opposition to the first defendant applicant's notice of preliminary objection, the claimant respondent filed a counter affidavit deposed by Olatunde Mobolaji Johnson, the second claimant in this suit. Attached to the counter affidavit are 8 exhibits, exhibits MJ1 to MJ8, and a written address wherein the claimant traced the sole issue for determination. That is to say, whether the notice of preliminary objection filed by the first defendant ought to be dismissed, particular regard being had to the membership status of the first defendant and his committee members in Medical and Health Workers Union of Nigeria. Legal counsel to the claimant argued that though the authorities cited by the first defendant in support of his application are the position of the law, however, the position of the claimant is that the authorities cited do not support the facts in this suit, as same is distinguishable. He contended that the applicant has not placed enough material facts before the Honorable Court to give credence to his assertions in the notice of preliminary objection, and the affidavit in support of same to entitle him to the relief sought. He referred the court to the case of Mrs. Betty Darego versus Attorney General, versus AG Leventis Nigeria Limited and 3 others, reported in 2015. Leonard Clemens Counsel submitted that the first defendant is not a member of the Medical and Health Workers Union within the definition of membership to which the said Rule 28 applies. That this suit is not between members of the union, rather it is between the union and a member as one party against non-members of the union as another party. So section 28, 1, 2, 3, 4, 5, and 6 of the Constitution does not apply. That the first defendant, having no record of payment of check-off dues to the union, either through the State Council's account or the National Administrative Council's account, cannot be regarded as a member of the union. That through number 4 of the Council of the Union prescribed the payment of check-off dues as a membership subscription, which means the payment of the check-off dues is a condition precedent to membership of the union. That for anyone that identifies himself as a member of the union in each branch, the state government or the federal government, depending on which, on whose employee he is, deducts the money due, deducts the monthly dues from their salary and remits them to the union. that the first defendant and all the members of the purported committee are not members of the union because they do not pay check-off dues to the union. Counsel urged the court to resolve the sole issue formulated in favor of the claimant respondent and hold that the first defendant is not a member of the union, having no record of the payment of check-off dues to the union, and so not entitled to be afforded the opportunity of any internal dispute resolution mechanism before being proceeded against. He urged the court to dismiss the first defendant's notice of preliminary objections. In support of the first defendant applicant's notice of preliminary objection, the first defendant applicant filed a further affidavit deposed by one Karim Mufutau, the vice chairman of the caretaker committee of the Osun State Executive Council of the Medical and Health Workers Union of Nigeria, under the leadership of the first defendant in this state. Attached to the affidavit are 3 exhibits, exhibits A1, A2, and A3 being payment vouchers, evidencing the payment of the first defendant check-off dues to the union for the months of March 2010, May 2010, and June 2023, respectively. The first defendant also filed a reply on points of law, wherein he reiterated his argument that the first defendant and members of the caretaker committee of the Medical and Health Workers Union, Osun State branch, paid their check-off dues. He concluded by submitting that exhibits A1, A2, and A3, and more importantly, exhibit MJ2, attached to the counter affidavit filed by the claimant's respondents against the application, show clearly that the first defendant and Comrade Karim Mufutau have been members of the union for more than 10 years, and no fact or document to show that they have been dismembered. Counsel submitted that the constitution of the union, payment of check-off dues by members is fundamentally different from remittance of check-off dues contribution by the State Council to the national account of the union. That while Rule 4B of the Constitution empowers the National Executive Council to suspend contributions of unemployed members or such other members as it may deem fit, and this would not change their status to non-members, there is no express provision in the union's constitution that dismembers a member for failure or refusal to pay check-off dues. Rule 3, sub 1 of the union's constitution provides for disciplinary measures to be taken against a member. Counsel submitted further that in a situation where the evidence of the adversary favors or supports that of his opponent, any such admission only strengthens the latter's case. Referring the court to Akonde versus Adisa and another, reported in 2012, LPELR 7807, Supreme Court. The first defendant then urged the court to grant the application. For resolution, the court, having regard to the facts and circumstances of this suit, the pleadings before the court and the processes filed in support and opposition to the grant of the instant application, the court distills the issue below for determination, and that is, given the circumstances of this suit, is the instant application meritorious or such that ought to be granted? The crux of the first defendant applicant's application is that this court lacks jurisdiction to entertain the instant suit, as the claimant's action is in non-compliance with statutory requirements, having regard to the provisions of Rule 28, sub 1, 2, 3, 4, 5, and 6 of the Constitution of Medical and Health Workers Union of Nigeria, which provides for resolution of conflict between members and the union, a position the claimant respondent vehemently opposes. It is right that jurisdiction is the lifeblood of any adjudicatory process, such that in the absence of it, Any proceedings, however ably and well conducted, will amount to a nullity. In determining whether or not the court is seized with requisite jurisdiction in a matter, the court is required to examine carefully the originating processes filed by the claimant. According to the first defendant applicant, the claimants ought to have complied with the provisions of Rule 28, which provides for an internal resolution mechanism for disputes between the members or dispute between members and the union before instituting the suit. And so the claimants failing to comply with this said provision robs the court of jurisdiction to hear the suit. In the case of Niger Development Company Limited versus Adamawa State Water Board and others, reported in 2008, citation supplied. A condition precedent was defined by Ogbuagu JSC, as it then was, as, quote, a condition precedent is defined as one which delays the visiting. A condition precedent is defined as one which delays the vesting of a right until the happening of an event, unquote. What that indicates is that there are instances where the law requires the doing of an act before a would-be litigator may properly commence an action in order to seek redress for wrong done to him. In such instances, where the matter is brought without the condition precedent being met, the defendant is permitted by law to raise the issue of failure to fulfill a condition precedent, and the matter is liable to be struck out. See Arik Air Limited versus Catering and Facility Solutions Limited, reported in 2017. See also Igbinedion versus Edo State Board of Internal Revenue, 2017. And also Unilag and Oluwasomi and others, reported in 2017. Citations all fully supplied. A condition precedent must be created expressly, either by the provisions of a statute, as in pre-action notice for government parastatals, or terms of a contract which the present case falls into. The first defendant applicant is raising the issue of condition precedent as provided in the party's constitution. Rules 28, 1, 2, 3, 4, 5, and 6 of the Constitution provides for internal conflict resolution mechanisms before commencement of an action in court. And the rule is reproduced as below. I am not sure I'm going to reproduce this now in court, because it has a rule 28 and it's rules 1, 2, 3, 4, 5, and 6 were reproduced. However, 6A, that for, sorry, 6A says this: for 5 above to be actualized, none of the organs shall sit on a matter for more than 3 months. B, when an organ does not conclude a matter before it within the stipulated time, the next organ shall automatically take on. And 6, Rule 28, sub-rule 6, goes on and on, it's very long. So there is evidence before the court that check-off dues were deducted from the first defendant's emolument on the Medical and Health Workers Union behalf. Whether or not remittances of such check-off dues were made to the union's national or state coffers is a different issue entirely. The latter will be an issue the union can take up against the employers of the first defendants. For purposes of the instant suit, and by virtue of the documents marked as exhibits A1, A2, and A3, attached to the applicant's further affidavit, and more importantly, exhibit MJ2 attached to the counter affidavit filed by the claimant respondent, the court can safely reach a conclusion that the applicant is a member of the claimants union in the absence of cogent evidence to show the contrary. In other words, the law requires a party who asserts to adduce evidence in proof of his assertion. See Section 131 of the Evidence Act as amended. If the document relied upon by the claimant containing lists of his members has thereon the name of the first defendant as a listed member, it behoves the claimants to produce other credible evidence showing that the first defendant withdrew his membership of the union or had his membership withdrawn for failure to remit or pay his check-off dues. Since that is not the case in this suit, it is the considered view of this court that the matter or dispute before the court is an intra-union dispute. See paragraphs 13 and 14 of the claimant statement of facts. Section 54 of the National Industrial Court Act defines intra-union dispute as, quote, dispute within a trade union or an employers association, unquote. Being an intra-union dispute, compliance with the provisions of Rule 28 of the Claimants Union and Part 1 of the Trade Dispute Act are condition precedents before the jurisdiction can be invoked. It is against this backdrop that this court resolved the issue of determination in the affirmative, and I so hold. Consequent on the above, the court finds merit in the instant application. The first defendant's applicant's objection is upheld, and this suit is accordingly struck out to enable the claimants exhaust its internal dispute resolution mechanisms before approaching this court. That is the ruling, and which doubles as a judgment. No, there's no others to cost. The parties are to bear their respective costs.
My Lord, we are indeed very grateful for the well-considered ruling, which is equally a judgment in this matter as it appears. Our prayer is that the Lord will continually strengthen the Lord, and as we approach the commencement of another new year, the Lord will grant the court more wisdom and strength to continue in dispensing justice that the nation awaits all the time. We are grateful, very, very grateful.
Thank you. Well, even though I didn't hear most of what you said, but I believe that it was a prayer, and I shall say amen to that. Thank you very much.
Anyways,
yes.
I'm grateful, Lord.
Yes.
Thank you, Your Lord.
Very well. So is there anybody who hasn't heard this case? I doubt it, because you have delivered all the judgments. 5 judgments and 3 judgments. Yeah, pray. I forgot to, I said, no, to take it. I didn't pick it. Who? Okay. Oh, wow.